If you are a Meghan Markle or Samantha Markle fan, today was a big day. And the reason why that today was a big day is that today is the day that Judge Charlene Edwards Honeywell issued a 58-page opinion. Don't worry, we're not going to read the entire opinion. We're just going to break it down to make it all understandable for you. She issued a 58-page opinion, and this is her decision about whether this case is going to go forward or if this case is going to get dismissed. So let's remember, this is a defamation case that Samantha Markle filed against Meghan Markle. Some of the basis for her filing this defamation lawsuit was the famous Oprah Winfrey interview with Meghan Markle, which has something like 50 million views, probably more than that. And there was also a Netflix series that was done, which certain statements were made, and also some statements that were made by Christopher Bouzy. Now, for purposes of this video, we're just going to discuss and analyze the statements that were made in the Oprah Winfrey interview that was directly said by Meghan Markle, and it's really very central to the entire case. And just as a spoiler, the judge didn't really buy any of the allegations that have to do with the Netflix series or the statements that were made by Christopher Bouzy. Now, it doesn't, again, defamation doesn't necessarily have to be that you are the one who spoke them or published them. It could be that it was published through an agent, but it's a little bit clearer when the person themselves is making these statements. And that's why we're going to just concentrate on what Meghan Markle actually said in her interview, and we're going to analyze how the court explained and gave their analysis on whether the Judge Honeywell, felt whether these rise for a claim of defamation. So first, let's remind ourselves of the interview. I'm going to play the clips of that were the subject of this defamation lawsuit, and then we'll jump into it. So take a look.
And Samantha Markle, your half-sister on your father's side, has written a supposedly tell-all book about you. What is your relationship with her?
I think it'd be very hard to tell all when you don't know me. And I mean, this is a very different situation than my dad, right? When you talk about betrayal, betrayal comes from someone that you have a relationship with, right? I don't feel comfortable talking about people that I really don't know. But I grew up as an only child, which everyone who grew up around me knows. And I wished I had siblings. I would have loved to have had siblings. That's why I'm so excited to be pregnant, so that Archie has someone. It was really interesting I mean, the last time I saw her must have been at least 18, 19 years ago. And before that, 10 years before that.
So you all weren't close? You didn't grow up together?
No.
She doesn't really know you?
No, she changed her last name back to Markle I think she was in her early 50s at that time, only when I started dating Harry. So I think that says enough.
All right, so those are the statements that Meghan Markle said. Now, before we jump into the analysis of the case, I just want to remind everybody where we are now. It's important to know where's the case holding when this motion was being filed to dismiss the entire case. So let's remember, what happened here was that Samantha Markle filed a complaint. Her first complaint she filed for defamation based on, in large part, this interview with Oprah. Then, a lot of times when you have a complaint filed, the defense or the defendant will file an answer. And then once the defendant files an answer, then discovery opens, and then there's times for deposition, and you can get documents, and you can send interrogatories. All that good stuff happens in discovery. But sometimes the defendant will not even answer the complaint in a way which either admits or denies the allegations, but rather what they'll do is they'll file a motion to dismiss the complaint outright, and therefore not even go to the discovery phase. And the basis for that motion is, in this situation, since we're in federal court, is called a 12b6 motion, which essentially is that even if we were to accept everything that the plaintiff said as true in their complaint, still they did not plead a recognizable cause of action. So even if we were to look at the complaint, accept everything that they said as true, still they haven't pled a cause of action here. And that's what happened in this case. Meghan Markle's team, they filed a motion to dismiss right away. That first complaint, they filed a motion to dismiss. Now, what happened then was the Samantha Markle team filed an amended complaint. So now that they filed an amended complaint, they're saying, okay, we're going to rectify any problems that the defendants have with this complaint, and now we should be able to get to discovery, right? Well, they didn't buy that because they filed another motion to dismiss. So now this is their second motion to dismiss, and that's to dismiss the first amended complaint, which is really the second complaint. So then what happened is that the judge told Samantha Markle's team, she told them, I'm going to give you one more chance to amend this complaint. You have one more chance. But I'm warning you that if you don't do it right this time, if you don't actually allege or plead a recognizable cause of action in defamation, then I may consider sanctioning you. It's called Rule 11 sanctions. Rule 11 sanctions stands for the proposition that a lawyer is not just allowed to file whatever they want with the court. You have to believe that what you're filing, the pleading that you're filing, or whatever you're filing, has merit, and that the arguments that you're making are genuine. But if you're filing a frivolous filing and you're making frivolous arguments, then the judge may impose Rule 11 sanctions. So she was warning the Samantha Markle team, I'm going to give you one more chance, one more bite at the apple, but I may consider that if you don't get it right this time, or if you don't really actually plead a cause of action, then I may impose Rule 11 sanctions. Well, that didn't scare the Samantha Markle team. They filed a second amended complaint. And do you think that at this point the defendant said, well, this is their third complaint, and now we're going to just regularly answer the complaint like we do in many other cases? No, they filed another motion to dismiss, and there was a response by the Samantha Markle team. Then there's a reply. Then there was oral argument, and then the judge said, I'm going to take it under advisement. I'm going to issue an opinion. And that's where we are right now. She just issued this opinion, this 58-page opinion, where she explores all of the laws that are relevant and all of the factual allegations, and gives her entire analysis about what she's doing with this case. So, again, the spoiler is that the Netflix statements and the statements that were made by Christopher Bouzy, who was retained by Meghan Markle, those are not, she did not find that they pled enough to be considered a cause of action for defamation. But we're now going to jump into that interview that Meghan Markle gave with Oprah, whether that is actually what her analysis was on that. So first, what the judge does is she sets out the legal standard. Now you have to remember, when the judge is looking at this motion, what is she allowed to consider? And what type of standard does she have to apply to the complaint that was, at this point, it's the second amended complaint, the third complaint in this case, what she has to look at. So first, she starts off with the legal standard, and this is what she says. To survive a motion to dismiss, she's quoting from a case, which I'm going to tell you about in 1 second. To survive a motion to dismiss under Federal Rule of Civil Procedure 12b-6, a pleading must include a short and plain statement of the claim showing that the pleader is entitled to relief. So that seems pretty simple. All you have to do is cite a short and plain statement of the claim and showing that you're entitled to relief. That seems pretty simple. And she quotes a case here. The case is called Iqbal. And for all the lawyers that are watching this channel, we're getting flashbacks to the first year in civil procedure, which is one of the first cases that you learn about in civil procedure is the Iqbal case, Iqbal and Twombly. And this talks about what you have to plead in the complaint. So here she's starting all the way from the beginning, first year of law school, Iqbal, where short and plain statement of the claim showing that the pleader is entitled to relief. Then she throws in some more law. Here's another statement. Labels, conclusions, and formulaic recitations of the elements of a cause of action are insufficient, which means that if you just say, for example, the elements of defamation, you put that in your complaint. You say, Meghan Markle, she, published something. You go through all of the elements of defamation, which we're going to do a little bit more later on. But if let's say in the complaint, Samantha Markle would say, and she did do this, that Meghan published something, it was false, and she did it with reckless disregard, but as all the elements, and you just say them as the elements, and you just basically match up the elements to what Meghan did. So you're just really stating the law and just making an allegation that the other person violated them. So that's not enough. You can't just label it, oh, this is defamation, what she did. You have to get a little bit more into the facts than just labeling it. That's not going to satisfy Iqbal. All right. Mere naked assertions are also insufficient. You can't just assert, yeah, she did this, that, and the other thing. You got to get a little more specific than that. A complaint must contain sufficient factual matter which, if accepted as true, would state a claim to relief that is plausible on its face. So you got to go through the factual matters, and if accepted as true, if we accept everything that the plaintiff is saying, would that state a claim that is plausible on its face? Now, in ruling on a motion to dismiss, a court is generally limited to reviewing what is within the four corners of the complaint. So when you're facing a 12b6 motion, which is what this motion was, what is the judge allowed to look at? The judge, generally speaking, is strictly limited to the four corners of the complaint, meaning she can't look at anything else, just the complaint, and to decide based just on the complaint whether this is a well-pled complaint. And if taken as true that they pled stated a claim that is plausible on its face. However, there's a very important caveat here, and this is really what's going to make the case here. However, it may also consider attachments or exhibits provided with the complaint. So if part of your complaint you attach transcripts, which is what happened in this case, they're attaching the transcripts that from the Oprah Winfrey interview and the other Netflix series and things like that. So the judge is allowed to consider those as well. All right. Now, let's understand what defamation is. What is defamation? Defamation comes in one of two forms. Either through libel. Libel is when it's actually printed. It's expressed in print. Or slander. Slander is spoken or oral defamation. So it can either be written, which is libel, or if it can be spoken, that is slander. So that is what defamation can be, one of those two categories. Now, what are the elements of defamation? We spoke a little bit about this before, but now we're going to get a little bit more into it. And this is what the judge lays out. Either type of defamation consists of the same element. So those two categories of defamation, it's still the elements are the same. Now listen closely. Number one, publication. So it has to be that you're publishing something. You can either publish it through the spoken word or you can publish it by writing it. Either one. Number two, falsity. It has to be false. And that's an important part also. It has to be that what you're saying is false. If it's defamation, then it has to be false. Number three, that the actor acted with knowledge or reckless disregard as to the falsity of the publication on a matter concerning a public official. So if it's on a matter concerning a public official, then the actor has to have acted with knowledge or reckless disregard as to the falsity of the publication, or at least negligently on a matter concerning a private person. So where does this fall? Is Meghan Markle a public official? And here is where both sides agreed that she would be considered a public official, and therefore it's a higher standard. It's a higher burden. Negligence is for a private person, but reckless disregard is the standard that's going to be applied in this case. Reckless disregard for the truth. Reckless disregard for the falsity, as to the falsity of the publication. Okay. Number four, actual damages. So there has to be actual damages that Samantha suffered. And five, that the statement was defamatory. So the statement has to be not just that it's false, but it also has to be that it's very negative. It's a defaming statement. Those are the five elements. And then the judge says that as to the third element, like we just explained, the plaintiff and the defense agree that Meghan Markle is a public official, and therefore it's a higher burden of reckless disregard. Now, what is considered defamatory? A statement is defamatory if it tends to harm the reputation of another by lowering him or her in the estimation of the community, or more broadly stated, exposes a plaintiff to hatred, ridicule, or contempt, or injures his business or reputation or occupation. And here is where some of the allegations were that Samantha lost out on business because of the statements that Meghan made, and that she was held in lower estimation by her community. She was ridiculed, etc. True statements that are not readily capable of being proven false, and statements of pure opinion, however, are protected from the defamation actions by the First Amendment. So, if it's true, the statement is true, or it's not it's not easily proven that this statement is false, or if the statement is pure opinion, those are protected. That's not considered defamation under the First Amendment. Now, who decides whether a statement is one of fact or opinion? Is that a determination that the judge should make, or is that a determination that a jury should make? So, this is what the judge, Charlene Honeywell, said, and she quotes a case. Whether a statement is one of fact or opinion, and whether a statement of fact is susceptible to defamatory interpretation, are questions of law for the court. So, generally speaking, questions of law have to be determined by the judge. Questions of fact are determined by the jury. So here there's a straight out quote that says whether a statement is an opinion or whether a statement is whether it is a fact, where the person's saying it as a fact, that is questions for the law, the questions for the court to determine, because it's considered questions of law. All right. Let's go through now some of the statements. We saw that video reminded us of some of the statements, and now we're going to take each of the statements apart. So this is the first statement. Oprah Winfrey said the following: "And Samantha Markle, your half-sister on your father's side, has written a supposedly tell-all book about you. What is your relationship with her?" To which Meghan responded, "I think it would be very hard to tell all when you don't know me. And this is a very different situation than my dad, right? When you talk about betrayal, betrayal comes from someone that you have a relationship with, right? I don't feel comfortable talking about people that I really don't know." So, what's interesting is that the plaintiff actually conceded in oral argument, apparently. They conceded that the first two statements that Meghan made, this is the first one, may be opinions. That they're agreeing that they're opinions and they're not stated as facts. And the third one is the one that they're more concerned with. The third one, they said, is incorrect only as to the amount of time that lapsed between visits. We're going to talk about that in a second. So that was the first statement. And this is what the court felt. This is what the court held. The court agrees that this first statement is, in the context of the interview, an opinion, which plaintiff essentially concedes, stating that, yes, the first two statements on their own may be opinions. Well, if you as the plaintiff or the plaintiff attorney admit that the first two statements are going to be our opinion, well, then what is the judge supposed to do? Disagree with with the plaintiff's own lawyers? No. So the court's going to say, well, you agree that it's opinion, so let's move on from that. And it actually, just to be sure, the court actually analyzes it under its own analysis and doesn't just rely on the fact that the plaintiff attorney said that the first two statements are opinion. And this is what the court said. The court can only conclude that defendant's statement is an opinion about her childhood and relationship with plaintiff. As the court noted in its prior order, defendant went so far as to qualify her statement with the word really, to make clear that she was not suggesting she did not know who plaintiff was, as plaintiff implies. So what was her answer again? She said, "I don't feel comfortable talking about people that I really don't know." So the judge says, why did she add really? Well, really tells me that she's not suggesting that she doesn't know who she is at all. She's just saying, I don't really know her that well. I really don't know. So that's how the court is understanding it, that it's just an opinion. Thus, as a reasonable listener would understand it, considering the qualifying terms in defendant's statement, she is merely opining that she did not have a close relationship with plaintiff. Now, what it means to be close, right? What does close mean? So, the judge continues, to share a relationship with someone so intimate that you really know, that person is a subject that might make good fodder for philosophical, psychological, or personal exploration. However, it is not capable of being definitively answered. What does it mean that a person is close with another person? Plaintiff cannot objectively prove that she really knows defendant or that defendant falsely felt that the relationship was not sufficiently intimate to justify use of the word betrayal. Because the statement is an opinion not readily capable of being proven, it is protected by law from a defamation action. So the judge says first statement is out, it's considered an opinion. Even though she said she used the word betrayal and she said that she doesn't really know her, that's just saying that she doesn't really know her. Of course, she does actually know her, but she doesn't really know her. And what does it mean, betrayal? Okay, those are all opinions, what Meghan was saying. That's how this judge felt. Now let's go to statement number 2. Statement number 2. But I grew up as an only child, which everyone who grew up around me knows, and I wished I had siblings. That's another thing that Meghan Markle said. This time, says the court, plaintiff fails to specifically allege falsity and instead attempts to tie in other statements from the interview, stating that in context, this statement was a denial that Samantha played a part in her life and her upbringing. So, the fact that Meghan said, I grew up as an only child, the plaintiff argues that that suggests that Samantha was not part of her life. And that's the problem. That's their problem. And therefore, the judge says, well, this is also clearly protected opinion. Defendant's statement came in response to a question about her relationship with plaintiff. She replied that she did not really know plaintiff and grew up as an only child. Further, she says that she would have loved to have had siblings. As a reasonable listener, and that's the important standard here, a reasonable listener, someone who's listening to this and has reason. So as a reasonable listener would understand that defendant merely expresses an opinion about her childhood and her relationship with her half-siblings. Thus, this statement is not objectively verifiable or subject to empirical proof. And that's going to be a running theme. Can you prove that this statement is true or false? If you can't prove it by any means, so then that's not going to be considered a statement. It's going to be considered an opinion. And that's why we're going to keep hearing this theme. We already heard it a few times, but is this something that could be proven? And that's what the case law stands for. If you can prove it one way or the other, then it would be stated as a fact. If it cannot be proven, it's just an opinion. So then if it can't be proven, then it's an opinion. Plaintiff cannot plausibly disprove that defendant feels she grew up as an only child and wished she had siblings. Because the statement is not capable of being proven false, it is protected from a defamation action. All right, well, that takes care of the first two statements. And like I said, the plaintiff's attorneys actually were okay. They acknowledged that the first two statements would be opinion. So most likely you're not going to get anywhere on those first two statements anyway. Now let's move on to the third statement. The third statement is, this is what Meghan Markle said, the last time I saw her must have been at least 18, 19 years ago, and before that, 10 years before that. So 18, 19 years ago, and then before that was like 10 years before that. That's what she said. So what does the plaintiff have a problem with this? What is Samantha's problem with this statement? Plaintiff concedes that this statement is incorrect only as to the amount of time that lapsed between visits. She argues, however, that it is objectively verifiable. Now here she's saying, well, it is objectively verifiable. I can actually prove this, that we did see each other less than 18, 19 years ago. Well, now you have a fact that could be proven. So now we're actually maybe getting somewhere. So the judge says the following. Again, she argues, however, that it is objectively verifiable that the last time plaintiff and defendant met was far more recent than the defendant said. And that's a quote from the plaintiff. So from the plaintiff's attorneys, their filings or what they said during oral argument, the judge now is quoting what the plaintiff's argument is regarding this third statement, that it was far more recent than what the defendant said. Defendant said 18, 19 years. No, it was far more recent. Here, let's see what the judge has to say about this. Here, plaintiff has failed to plausibly allege that defendant's statement was substantially and materially false, as she must to state a claim. So, another thing that you have to do is you have to show that the publication was substantially and materially false. And here, the judge is saying that plaintiff has failed to plausibly allege, again, was she saying allege because this is what they put in the complaint, allege that defendant's statement was substantially and materially false, as she must to state a claim. This conclusion follows from a few premises. First, plaintiff admits that the statement alone is unlikely to support a claim, as it is incorrect only as to the amount of time that lapsed between visits. So if it's only incorrect as to the amount of time that lapsed between visits, it's not substantially and materially false, right? So that's what the first thing is. Next, plaintiff responds that it is objectively verifiable the last time defendant saw her was far more recently, and she puts this in quotes because this is exactly what the plaintiff said, that it was far more recently. This conclusory assertion in a response, omitting when their last meeting was, what is meant by far more recently or any further detail, does not allow the court to plausibly infer that defendant's statement was substantially and materially false. You didn't say when they actually saw each other. You're just saying, well, they saw each other far more recently. Well, when was that? That's very important if it's going to be substantially and materially false. If it was instead of 18 years, it was 17 years, well, that's not substantially materially false. If it was 2 years ago, then maybe you have a case. But all the plaintiff argued in this case was that it was far more recently. So the judge has a problem with that. Additionally, defendant is right that a mistake regarding whether she saw plaintiff 13 or 18 years ago would be protected by the substantial truth doctrine, as the gist of the statement is the same. And this is another part of defamation that we have to understand. If the gist of the statement is true, so then even if technically the statement itself is not true, but the gist of the statement is true, so then that also would not qualify for defamation. So the defendant argues in this case, this is Meghan Markle's team, they argue that even if it was 13 years ago, which it seems to be that there was some suggestion that they saw each other 13 years ago instead of 18 years ago. If it was 13 years ago as opposed to 18 years ago, so still, the gist of the statement is that she hasn't seen her in a very long time. That's what Meghan is trying to convey in that interview. I haven't seen her in a very long time. Yeah, she used 18 and 19 years, but if it's 13 years, the defendant argues that the gist of it is the same. And the case law is clear that if the gist of the statement is still true, then it would not qualify as defamation because it's not technically what would fall under a false statement. Now, listen to the court because you got to have a little bit of humor. Regardless of how the parties did their math, and then she put in parentheses here, plaintiff did not exactly show her work. The court agrees with defendant that the gist of the statement that it has been over a decade since the two last saw each other is the same. Therefore, the statement is protected by the substantial truth doctrine. And that doctrine is that if it's substantially true what the person is saying, so then you can't, even though it's technically false, that's not going to cut it for defamation. Moreover, defendant qualified her statement by stating the last time she saw plaintiff must have been. And she also said at least a certain number of years ago. This language would give a reasonable viewer the impression she was relying on her memory and providing approximations rather than drawing from documentary evidence or undisclosed facts to come up with a number. So you see clearly that Meghan's just trying to use her memory and not documented facts. So to a reasonable viewer, a viewer would see that as, oh, that's Meghan trying to jog her memory with exactly how long ago was that they last saw each other, but not that, oh, I'm quoting from an absolute fact, that I have the facts right in front of me. And that makes a difference. All right, now let's move on to statement number 4 and statement number 5 in this specific interview. So Oprah Winfrey asked the following question. So you all weren't close. You didn't grow up together? And here Meghan said, no. Next, Oprah Winfrey, she doesn't really know you. To which Meghan responded, no, she changed her last name back to Markle, and I think she's in her early 50s at that time, only when I started dating Harry. And so I think that says enough. That was Meghan's 2 statements. Number 1 was no, when Oprah asked her, so you weren't close, you didn't grow up together. That was no. And then also, when she said she doesn't really know you, she said yes, and then she starts talking about when she changed her name, when Samantha changed her name from Rasmussen to Markle. So, here we go. Defendant's first alleged defamatory statement consisted of her answering no to the question of whether she and plaintiff grew up together. Again, defendant's answer in context is clearly her opinion of her own childhood and relationship with plaintiff. It is neither objectively verifiable nor subject to empirical proof. Is this statement objectively verifiable? Can you prove this one way or the other? So the judge feels that no. Therefore, it cannot support a claim for defamation and must be dismissed. Plaintiff's attempt to explain why this statement was false, in fact, supports this conclusion. So here the judge is saying, well, plaintiff tried to make some arguments here, but actually, plaintiff's arguments actually support this conclusion. According to plaintiff, defendant's single word answer called into question plaintiff's various fond memories, and she puts it in quotation marks because that's a direct quote from the plaintiff, that it calls into question plaintiff's fond memories of them growing up. An occasion or period in time that one person remembers as a fond memory, quote unquote, may be remembered quite differently by others. And either way, an individual's feelings about the past are not objectively verifiable. So whether you have certain feelings about the past and another person disagrees with those feelings is not something that you can prove. So since you can't prove it one way or the other, then it would fall under opinion. If it's an opinion, then it doesn't qualify for defamation. Therefore, plaintiff's claim as to this statement, which would ultimately have to establish that the two half-sisters grew up together, whatever that means, and or were close, falls outside the boundaries of a plausible defamation claim. How do you prove that you were close? How do you prove that? And how do you prove what growing up together means? So the judge felt that doesn't qualify for defamation either. Next, the court considers the second part of the statement regarding plaintiff's name change. So here is where the plaintiff argues that the statement was false and harmful because it was not the time that she began to use the name Markle. Based on the materials that have been judicially noticed in this case, this claim must be dismissed based on the substantial truth doctrine. So again, now we're using the substantial truth doctrine. Is that statement substantially true that she changed her name back to Markle when Meghan started dating Harry? So, based on the materials that have been judicially noticed in this case, this claim must be dismissed based on the substantial truth doctrine. In addition to plaintiff's failure to plausibly allege actual malice. Now remember, there's also another element of actual malice. Were you able to prove that Meghan was using actual malice? Just to get the exact. Reckless disregard. Was she acting with reckless disregard as to the falsity of that statement? So the judge says also that the plaintiffs failed to allege that actual malice was present here. The court has taken notice of the fact that plaintiff used the surname Rasmussen in September 2016 and Markle 2 months later. So she did use both names. Part of the argument here was that the plaintiff didn't officially change her name to Markle till much later, but she was using both names interchangeably. So the court says, well, in September 2016, the plaintiff, Samantha Markle here, was using the surname Rasmussen as well as Markle 2 months after the Meghan Markle's royal relationship was first reported. Therefore, the gist of the statement that plaintiff switched to her family name a short time after it was reported, defendant was involved with Prince Harry, is true. So the gist of the statement is true. She doesn't have to say that she actually legally changed her name, but was she also using the name Markle 2 months after the relationship with Meghan and Harry was reported on? Yes. So that is enough. That's the gist of the statement. It is true that she did start using Markle. Now, whether she legally changed or not, that's not the point. Moreover, the precise reasons for her switch were not specified or suggested by defendant. An amorphous statement that cannot be objectively verified. So that's another reason. That plaintiff used one last name and then the name Markle soon after reports of the defendant's relationship with Prince Harry were published is substantially true, based on the exhibits in the record of which the court has taken judicial notice, and the court cannot reasonably infer otherwise. So that does it for all of the statements, and therefore the judge said all of these statements either are substantially true, you can't prove that there is actual malice, or it's clearly opinion. Now, there was one more, in case you think we're done, there was one more cause of action that the plaintiffs alleged in this case in one of their amended complaints, and that was defamation by implication. Now, this is where it gets a little fun. We spoke about this in our previous video on this, but let's just briefly talk about it again. Regular old defamation is all of those elements that we spoke about. You publish something, it was false, reckless disregard, and some of those it was suffer damages, and it was defamatory. All right, so those were the elements in defamation. Defamation by implication works a little bit differently. And the way that this works is that really what you're saying is actually true. The actual literal facts that you're saying are true, but you do it in such a way that the implication from what you're saying paints a picture which is false. So that's a little more nuanced. The actual facts, statements that you're making are true, but because you juxtapose them in a certain way, it painted a picture which is actually false. So that's defamation by implication. So the plaintiffs also alleged defamation by implication. Now listen to this. Under Florida law, defamation by implication applies in circumstances where literally true statements are conveyed in such a way as to create a false impression, which is what we just explained. The court agrees. First, plaintiff fails to adequately state a claim for defamation by implication for a simple reason. Here we go. Ready? This is the simple reason. She fails to identify the literally true facts that would serve as the basis for such a claim. So in order to make a claim of defamation by implication, you have to identify for the court which statements are literally true, and then explain to the court how those statements, even though they're true, but they paint a picture that's false. So here, the plaintiff failed to identify, well, tell us which statement that Meghan made is true. In fact, plaintiff consistently alleges that all the statements based upon which she alleges defamation were false. So here you have Samantha saying everything that she said was false. And that's why I'm suing her in defamation. Plain old defamation, not defamation by implication. And now you're trying to flip the script and say, you know what? Really, all of her statements are true, or some of her statements are true. But by implication, it shows that a false impression. Well, which statements were true? Because you never told us. All that we've been hearing, the court is saying, is that all these statements are false. Thus, her complaint logically precludes a defamation by implication claim as she fails to specify the true facts defendant manipulated to create a defamatory implication. With this background in mind, the court can largely put aside plaintiff's many allegations regarding defendant's false statements and why they were false in analyzing this count. Where plaintiff does begin to suggest that defendant has manipulated true facts, her allegations are insufficiently vague. So even where there is some sort of implications or arguments or allegations that maybe some facts could be true, but that also paints a false picture, those allegations are insufficiently vague. All right, and that's why the judge finally comes to the conclusion here, dismissal of both claims with prejudice is warranted. So if it's with prejudice, that means that they can never bring this case ever again. Anything to do with the Oprah Winfrey interview, anything to do with the Netflix series, anything to do with this Christopher Boozy person, nothing ever can be brought again in this as a lawsuit again for defamation. So again, here dismissal of both claims with prejudice is warranted. Plaintiff has been given several opportunities to amend, along with guidance and a reminder to be mindful of Rule 11, as we spoke about. Nevertheless, plaintiff's amendments were sparse, often contradictory, or unsupported by authority whatsoever, and largely failed to cure deficiencies identified in the court's previous order. So here the judge really brings the hammer down on the plaintiffs here. Really strong words that you just guys completely missed the boat. I gave you so many opportunities and you just can't get it right. And therefore, in the conclusion, accordingly it is ordered, defendant's motion to dismiss for failure to state a claim is granted. So the motion was granted. Plaintiff's defamation claims are dismissed with prejudice. Plaintiff's defamation by implication claims are also dismissed with prejudice. Now, does she order sanctions? Well, not in this opinion. So if there's one saving grace for Samantha Markle legal team, it is that they were not sanctioned by this judge. Well, that does it for now. Please, if you haven't yet, subscribe, like this channel. We're bringing you all types of different trial analysis and all the important legal news that is going on. Please subscribe, like, and we will see you next time.